Thank you, Rod. Delighted to be the last of these webinars. It's been a great engagement with everybody doing these throughout the past few weeks, and hopefully we'll keep them as a bit of a major fixture now and then, maybe not quite as intense as we have been doing. But if you've not joined before, I'll take you through a little bit about the firm, a wee bit about me, and then we'll get into the talk itself, which, as Rod says, is all about insurers, panel solicitors, and claims management companies. Before I tell you about them, let's tell you about us. Now, for those of you that don't know, we are a specialist firm representing vulnerable road users. So the name of the firm is Road Traffic Accident Law Scotland LLP, and we have 3 brands which we operate under. The first of which is Motorcycle Law Scotland, the second is Cycle Law Scotland, and the third is Pedestrian Law Scotland. So our primary concern is representing vulnerable groups of road users if the worst has happened to them and they've been involved in an accident. Obviously, I have my motorcycle law hat on tonight because I'm addressing motorcycle incidents, but as a firm as a whole, this is the service we offer to vulnerable road users. We cover the length and breadth of Scotland, and the key difference with us is we are independent. So we don't buy in cases from insurers. We don't have recommendations coming from third parties. We rely entirely on clients coming directly to us, which is why we have strong links in the motorcycle community. And as well as that, a lot of our staff are also motorcyclists, because we believe that not only do you have to be walking the walk, you have to talk the talk, and to do that, you really need to put yourself in the shoes of your clients. On that point, a little bit about me, I suppose, as well. For those of you that don't know, if you haven't come to one of my webinars before, I'm Thomas, as I said. I got my motorcycle license in the summer of 2018. Now, that was the first time I was able to ride bikes on the road, but I have had a long history riding them rather badly off-road before that as a kid. That's me up there on the slide. You can see almost falling off my trials bike, which is a new thing I've discovered, and it's wonderful. I really enjoy it. Apart from that, my legal training, I did my law degree up in Aberdeen, suffered 4 years up there in the cold and the grey, and came back to Edinburgh to finish off my legal training, and I've been a solicitor here at Motorcycle Law Scotland for almost 2 years. So in relative terms, I'm quite new in the game, but I run my own case holding. I have cases in summary cause courts, the All Scotland Personal Injury Court, and the occasional one in the Court of Session. And I really enjoy the work we do at Motorcycle Law Scotland because it allows me to combine my passion for motorcycling with helping people at the worst point in their lives. And the idea is you come into people's lives when they're at their lowest and try and leave them a bit better than you found them. Now, getting into the meat of tonight's presentation, I'm no insurance salesman, but I think we should at least glaze over a bit about what insurance is before we get into the slides further on down. Basically, in order to ride your motorcycle on the road, you need to insure it. There is provision in the Road Traffic Act, section 143, I think it is, which says you have to have at the very least a policy of third-party insurance cover. And there are different types of insurance you can get. You can have fully comprehensive, which covers both you, and if you're involved in an incident where it's your fault, you'll also be covered because you won't have to pay out for the damages to the other person. The other type is third party, when you're only insured for third party incidents. They vary in cost, but the thing to remember is the insurance is for your motorcycle, it's for your property. Insurance is not for you. We think of insurance as being for us, this very personal thing, I'm insured, you're not insured. But at the end of the day, all you're doing is insuring a piece of your property. And it's a contract between you and the insurance provider. Very important to remember that. Some of us always get caught up in the small print. We don't like to read our insurance contracts. Trust me, I read them a lot and it's not a pleasant thing to do, but sometimes it's quite important to read your insurance contract to see exactly what there is in the small print, because that's where things can sometimes become a little bit difficult. Now, there are lots of different types of insurers out there, and even I get lost in the sea of who's an insurer, who's an underwriter, who's a broker, they all kind of merge into one big entity. And a lot of insurers on the face of it are really just admin faces. They don't tend to do the heavy lifting if you're unfortunate enough to be involved in an accident of your own. And insurers themselves, they make a lot of money. A well-known broker, MCE, in 2017, their profits were north of £10 million. And that was an increase on their profits in 2016, which just glazed the £1 million mark. So you can see this is certainly a growing sector. And a lot of them are subject to very complex management structures. And sometimes, as I say, it can be very difficult to kind of determine who's what and who's who. And a thing which is happening an awful lot is upselling of insurance products. And I'm no expert on insurance products, but there's one product in particular which is always upsold and something which you should really be looking out for. And that is legal expense insurance. Now, there's a wee button that you can do if you put your hand up. It just alerts us to know that you're watching. But hands up, anybody who has legal expense insurance. According to a recent poll, approximately half of us take out this insurance add-on whenever we get a policy. And I'm going to use quite strong words here because effectively legal expense insurance in relation to motor claims is a bit of a sham. And why is it a sham? Well, effectively what a motor insurance policy is for you is a way in which your insurance company to find out when you've been involved in an accident. Because they know that when you're involved in an accident, you're going to be calling them first and foremost. And when they sell you this legal expense insurance product, what that allows them to do is effectively you're able to, weasel a little bit extra out of you, the policyholder, but you don't need this. You're always entitled to instruct your own solicitor. But why are they so keen to sell you this legal expense insurance? If an accident was your fault, your insurer is not going to care. If an accident wasn't your fault, but you weren't injured, they're still not going to care. But if the accident wasn't your fault and you were injured, then your insurer will fall over themselves to help you out. And even better, they'll sort you out with a solicitor all at the same time, all because you've got legal expense insurance. And it's sold to you as having a top team, a crack team of lawyers for, say, £30 a year. Fantastic. Rubbish. That is not what legal expense insurance is. And what effectively happens is your insurer will palm you off, if you're injured, to a panel solicitor who will deal with the uninsured loss. So anything apart from your motorcycle will be dealt with by a panel solicitor. Now, the panel solicitor is a common beast in the personal injury sector. And whilst they can do an effective job, their service falls well below that of an independent specialist like Motorcycle Law Scotland, for example, or any independent personal injury firm. They are known as so-called experts, but in truth, they are anything but. A lot of the time, they'll be able to offer a zero fee charging structure. So they'll say to you, we've been instructed by your insurer because they've told us you've been involved in an accident. Here's some paperwork for you to sign. We will sort out the personal injury aspect of your claim. We won't charge you anything for doing this. You'll be entitled to keep all of the damages we recover for you. And how are they able to do that? Well, the reason they're able to offer this service is because us as solicitors, we get paid on conclusion of cases. There are fees we are able to recover, which are paid by the at-fault insurer for our time on the case. Now, when you have a zero fee charging policy, what is going to happen is they're going to be recovering their fees from the at-fault insurer. So that's where they get paid. But the difficulty comes a lot of the time with low value claims. So for example, a minor injury claim where you have a panel solicitor offering a zero fee charging structure, say the case settles for £2,000. Their fee, which is calculated in relation to some legislation I won't bore you with, would be around about the £1,000 mark. It would be just north of £1,000. So you get your damages, but they get their fees. Now, if they get that £1,000 from the at-fault party, but they've bought in your case from your insurer for, say, £500, the difficulty is that half the revenue that that panel solicitor will make from your case is gone before they're even out the door. They're making £1,000 from your claim, but they've had to buy it in for £500. So they only have £500 to play with. That's the maximum amount of money they're going to make from your claim. So are they going to dedicate a lot of time to actually making sure that your case has progressed as well as it could be? No. Are they going to be expending money on highly qualified staff to be able to do that? No. What they will do is they will commit as little time as possible and as little expenditure as possible in order to ensure that they can maximize the amount of money they can make out of your claim. And that's the difference between us and a panel solicitor. We cannot offer a zero fee charging structure. And the reason for that is because the service you are provided is far and away above that of spending as little time and money as possible on your claim. If you come to us, you are a dedicated solicitor, number one, first and foremost. A solicitor will deal with your claim. You won't have a claims handler, you won't have a paralegal, although they can progress a claim quite well. It's not the same experience. We will dedicate every hour that we possibly can to your claim and treat you as an individual. And always remember, you have the right to choose your own solicitor. This is my most important takeaway message tonight, is whilst there are panel solicitors out there, you have a right to choose. Now that's panel solicitors. Also, a little bit about accident management companies, because the two kind of go hand in hand. And I'm well known in the firm, this is my pet project. I don't like accident management companies very much, and with good reason. Added to the mix of these panel solicitors, you have what are known as the vultures of the insurance industry. Now, vultures like to fly around and pick off the carcass of anything which they can get. That's what an accident management company is. They are often appointed by your insurer to do the heavy lifting in relation to your claim. So you call up your insurer, you say, I've been involved in an accident, I'm injured, and my beautiful Ducati Monster is damaged and needs to be repaired. Can you help me? And your insurer goes, yes, sure, no problem. And then you receive paperwork for a company like Fourth Dimension or Plantech. And they'll go, hello, Mr. So-and-so, we're here to help you. We'll take away your bike, we'll have it assessed, and we'll even give you a hire bike if you want. And if you can ride it, no problem. We'll sort everything out for you. You don't need to worry. So they deal with the insured loss, and then you're palmed off to a panel solicitor for your personal injury. Now, these accident management companies act in the guise of helping you get back on your feet, but what they are doing in reality is they are concerned with lining their pockets and using you as a vehicle to do that, because they get their expenditure back from the at-fault insurer in all of this. And they do this through two effective techniques. The first is a credit hire agreement, and the second are storage hire agreements. Now, these agreements are something which you may be, I don't want to use the word tricked because you're always entitled to read the paperwork, but they are sometimes sold to clients on the basis that it's going to help their claim progress more quickly, or that it's a benefit for them. So a credit hire agreement, whether it's for the hire of a motorcycle or a credit storage agreement, is exactly that. It's been made on a credit basis. So you're told by these accident management companies, yes, we can sort you out with a credit hire motorcycle, and you sign on the dotted line. And there is a daily cost to hiring that motorcycle, but it's okay because they say that they'll claim the money back from the at-fault insurer. Fair enough, that's fine. So you're able to still get around. You're riding this haggard old bike they've given you, and they're charging all the time for the pleasure of you riding this at £150 a day or whatever it is. Now, when your bike has been assessed and then fixed, repaired, or written off, the credit hire bike comes back to Fourth Dimension or Plantech or any of these accident management companies, and there's a very large bill to pay. Now, normally on the chopping block for that bill is a third-party solicitor who's insurer, who's at fault. The difficulty with these credit hire agreements, and what they never tell you, is that if they can't get those inordinate hire charges back from the at-fault insurer, if the at-fault insurer turns around and says, well, hold on, this person you provided a credit hire bike to has another motorcycle, or they have a car they could have used to get around. Why are you giving them a hire motorcycle? Is that reasonable? Then what the accident management company can do is they can turn around and take the money from you because you have the hire vehicle on credit. If they can't get their funds back from the at-fault insurer, they're coming after you. Better believe it. So always, always, always read very carefully anything you get, which is a credit hire agreement or a credit storage agreement. You always have a duty in any personal injury case to mitigate your loss. And you might find yourselves at the mercy of one of these accident management companies, all because you thought they were helping you out. Now, I do have some real life case studies to demonstrate how things can sometimes go a little bit wrong when you're dealing with panel solicitors and accident management companies. And the first involves a case. The gentleman was riding in a northwesterly direction on the A830, and he was about 15 miles south of Maleg at the time. And he began a procedure to maneuver into a near-side lay-by when he was hit from behind by a vehicle. And the accident happened in August 2019. Now, this gentleman quite rightly reported the incident to his insurer, who were Bennett's at the time, and Bennett's had palmed him off to the panel solicitor who they had on their panel. So the panel solicitor was dealing with the personal injury aspect of the claim, and guess who was dealing with the motorcycle? Fourth Dimension, our good friends. So Fourth Dimension were involved to repair this gentleman's Aprilia, and they'd picked the motorcycle up and they'd assessed it, and they'd taken it all the way down to Surrey, and in the meantime, the transfer was to a panel solicitor to deal with the uninsured losses. Now, an initial contact had been fine. The client did not have an issue with the panel solicitor for the initial contact stages. What he did have an issue with, however, was after that initial contact, a lot of communication just tailed off rather rapidly. He couldn't really get a hold of his solicitor. What we're seeing really is the fact that these panel solicitors have very little resource to expend because they've already expended a resource on securing the case. And this gentleman asked us to take over acting. Now, ordinarily what happens is when you take over acting from another firm, you request the file of papers and they will intimate a fee for the work they've done. And the work so far between August and October that had been done by this panel solicitor was amounted to £1,450 plus the VAT, which they were very kindly keen to restrict to £1,500 all in. An awful lot of work for not many months and not much client communication on file. But the most concerning thing with this case was that the gentleman had entered into an agreement with the accident management company, Fourth Dimension, which entitled them to 25% of his compensation upon conclusion of his claim. 25%. 25% for what? What would the accident management company do? What could they possibly do to justify retaining 25% of this gentleman's damages? The answer is nothing. And this is the first time we'd seen such an agreement, and we brought it to the attention of the panel solicitor, who pointed the finger at Fourth Dimension, and then we asked Fourth Dimension what this was all about, and they pointed the finger at the panel solicitor. Since we've not seen this irrevocable mandate appearing in any other cases which we've had to take over from this particular panel solicitor, but it was something, thankfully, the client was able to avoid, and we got him out of this awful agreement. Any sane solicitor in their right mind would not have advised this client to sign that irrevocable mandate. You can't have an accident management company asking for 25% of somebody's damages, particularly if they're not doing anything. What could Fourth Dimension possibly do in relation to concluding this gentleman's claim? Nothing. They don't have qualifications, they don't have the staff, they don't have anything. They manage the accident. They have nothing to do with the conclusion of the claim. And it was one of those situations where you thought, oh my God, what is this? But at the end of the day, we were able to take over acting for the client and bring his claim to a successful conclusion. And he was able to get out of this particular agreement and no further action was taken. And it's just a message, be very wary of things you sign. Always read the paperwork. The second case study is once again a bit of a panel solicitor and Fourth Dimension stitch up. I don't want to keep referring to Fourth Dimension specifically because at the end of the day, they are entitled to carry out their business. They're an accident management company. That's a service they provide. I don't mean to always pick them out, but in these examples, they do tend to appear every now and then. But just to say, this is not a direct attack on them. It's just an explanation as to the parties who are involved. So this particular client, you can see up there, this was actually an image from the accident itself. It had been a contraflow system up in the Highlands, and the lights had gone green for him. And the lane which was open is that lane you can see the white VW in. And the lane that was closed is the lane you can just about see a van parked in. Now, the lights had gone green for my client and his partner who was following him on the bike behind. And they proceeded around what was for them a left-hand bend, blind left-hand bend. And all of a sudden they were confronted with this big van, which appeared to be on the wrong side of the road. And it must have jumped the lights if it was actually traveling the opposite direction to them. But because the lane was closed, he was in the wrong lane. Our client took evasive action, swerved to the left, managed to get his bike stopped and over, but his partner, she had to hit the brakes as well, and she went down. Both of them injured, but thankfully not terribly injured. But both the bikes required a bit of TLC and repairs. So following the road traffic incident, my client contacted his insurer. And because the bike required repairs, Fourth Dimension were instructed to manage that part of the accident. And he was provided with a hire motorcycle on credit hire. And the client was told on no uncertain terms that if you take this hire motorcycle, your claim will be resolved more quickly. Because he was quite apprehensive about taking the hire motorcycle because he'd read the contract and he could see that it was on credit. And he thought, well, if this is on credit and they're not able to recover their costs from the other side, I'm going to be on the hook here. I'm not so sure I want to take this on. But he was swayed away from that by the company providing the credit hire. And they said, no, your claim will be resolved much more quickly if you just take the hire bike, ride it around for a bit, all fine and dandy, no worries. So he took the hire bike. His claim was never resolved quickly. The reason for this is the insurer who represented the driver of the van denied liability. They said, we're not at fault. Your client has come round a blind bend. They should have been able to stop in time. The accident's his fault. So he's now in a situation where we have a difficulty in relation to liability, and we have a credit hire agreement that's around about the £7,000 mark that the client could potentially be on the hook for had we not fought the claim. A panel solicitor might have turned around in that situation and said, whoa, liability has been denied. We might not be able to raise court proceedings for you because, we don't have the resource to do that. They'd never say that, but that's the reality of it. We weren't of that view. We raised court proceedings for this client and we fought the claim. Because at the end of the day, the evidence suggested that he had done nothing wrong. We had a good independent witness statement from the driver of the VW confirming that the lights had indeed been green and that this van had come round on the wrong side of the road at a blind bend, failed to make anybody aware of his presence, and everything our client had done to avoid a more serious collision had been reasonable. But there was a difficulty overall in relation to settling the claim because the claim wasn't worth a huge amount of money. It was quite a moderate value claim. But we had the £7,000 credit hire charge, which they are entitled to get back, but they have to include it as part of the litigated amount that we sue for. So it's now my job to try and recover the outlays of this accident management company. Joy for me. And the difficulty I came up against was my opposite number, the solicitor representing the insurer of the van, said, why is there £7,000 of hire charges here? Your client has a van he can drive. This isn't his only form of transport. He rides a motorcycle for leisure. Why has he had a motorcycle in the first place? And I can't exactly turn around to them and say, well, he was told to take one by the credit hire company, because that's not a very good argument. So we were able eventually to negotiate down Fourth Dimension's credit hire from £7,000, which they said was a reasonable amount, to £1,500. They accepted £1,500 in relation to their hire. And when it came to settlement negotiations, there was never any concession on liability, but when we were looking at whole figures, we were able to ensure that the client still received what was a reasonable amount in damages, and that he was no longer on the hook for those huge credit hire charges, and they'd been reduced and they'd been accepted, and they'd accepted a much lesser amount. But it just shows you they're asking for 7,000, but they accept 1,500. Take from that what you will. The third case study is a little bit of a sad story. Unfortunately, it demonstrates how you can sometimes be trapped in these agreements. And whilst we would always encourage you, if you're unhappy with the job your panel solicitor is doing, to come to us, it's always best to do this at an earlier stage as possible, or at the outset of your claim, where you say to your insurance company, no, I'd like to appoint my own solicitor to deal with my uninsured loss, because that's your entitlement. You can do that. There's nothing wrong with doing that. Remember, your insurance policy covers your property, not you. But this particular client contacted us just this month, and he was quite unhappy from a panel solicitor who shall remain nameless, but it's the same panel solicitor who appear in every one of these case studies. And unfortunately, what this panel solicitor were insisting on is an upfront fee be paid for the transfer of this gentleman's file. And without this fee being paid, they would not hand over his file of papers. Now, we made a reasonable proposal to them to pay a slightly less amount so that we could access the file and then progress it on in a more appropriate way. They refused. They flat out said, no, we will not accept a lesser amount, which is quite a strange thing. It is accepted that if you have a previous solicitor working on your file, that they will have obviously incurred costs in progressing your claim. Even if they're doing a terrible job, they're still incurring costs, and they're entitled to charge for those costs. But there comes a level where it gets a little bit unreasonable. And normally what happens is you say to the previous solicitor, okay, I can pay your fees, but I'll do that once we're able to conclude this gentleman's case. Because at that stage, we all get paid. It's on conclusion. The risk, if you're paying up front, is that the claim is never going to be worth an amount which would actually ensure that the client got a decent amount of damages, or that you, as the person taking on the file, got paid. And whilst we do everything we can to help our clients, we're not in the business of doing this for free. We do need to be paid by the other side, particularly if we're doing a job which is particularly difficult. And nobody would say it's unreasonable for somebody to be paid for the work they're doing. So our intention was always to try and help this man get out of this agreement. And we made the best proposals we possibly could, but we were flat out told by the panel solicitor, no, you have to pay this fee up front. And at the end of the day, our duty has to be to the client first and foremost. Our intention is not to maximize our fee. Our intention is always to do the best we possibly can for the client. And I had to tell this gentleman it would be financially prohibitive for him to actually move to us. And it's one of the only occasions I've had to do that. And I hope it's the last, because I hope panel solicitors will become something which people are more aware of and know not to go with them if they're unhappy with the service, or if they do twig at an earlier stage, to come to us as quickly as they possibly can. Because there are situations where it is financially prohibitive for you to possibly change solicitor, and that's if you're way on down the line, because the agreement you sign is always going to have a clause in it to say, if you choose to bin us, you have to pay us for all the work we've done up until this point. So always be very wary of what you're signing. Now, those are a few in relation to accident management companies specifically, and a panel solicitor. But this one was one that made it all the way to court. And I'll just set the scene for a minute. This gentleman was an Irish fella, and he'd come over, he was riding his motorcycle in Scotland, and it was a rather strange set of circumstances. It was a lovely May day, and him and his two pals from Northern Ireland were all traveling kind of towards the Stranraer area. And one of his friends was actually a serving police officer, all highly experienced motorcyclists. And our client was approaching the rear of this vehicle you can see in the image. And he'd moved himself into, for those of you who are IAM trained or IAM riders or are aware of the IAM principles, he'd moved from a following position to a position where he was about to get ready for an overtake. So he'd closed the gap between him and the vehicle in front of him. And he was looking for an appropriate time to make his move. Just when he was about to make his lifesaver check to move out, the vehicle stops dead in the middle of the road. No reason why. Nobody ever understood why. And poor old Mr. O'Donnell went into the back of the vehicle. Nothing he could do. He couldn't go left, couldn't go right. He tried to avoid it, but he absolutely could not. Went straight into the back of this vehicle, which had stopped in the middle of the main road for no apparent reason. Now, following the incident, he reported it to his insurer, MCE. And MCE transferred him across to a panel solicitor. And the panel solicitor took one look at this incident and said, yeah, looks like it's pretty difficult for you, Leslie. It's an 80-20 split, and the split's not in your favor. So Leslie was basically told that any ordered damages he could have secured would have been reduced by 80%. Because effectively, whilst primary liability could be established, he bore 80% of the contribution to the accident circumstances. Leslie was pretty furious with this advice, especially considering he hadn't done anything wrong and the vehicle appeared to stop for no reason. So he came to us, and I remember sitting in court. This case proceeded in the All Scotland Personal Injury Court, and I sat next to a regularly instructed advocate of ours, Grant Markey, and I was furiously taking down notes, and it was fascinating as the evidence came out exactly what had happened. But before we got to that point, our very own Brenda Mitchell had done what should have been done in the very first place. And she went to Ireland and she took witness statements from both the friends. She investigated all of the circumstances surrounding the incident, got the police evidence in, chapter and verse, everything you'd expect of a competent and decent solicitor to do. And it looked as though Leslie had a good case. There was good witness evidence that he hadn't been doing anything untoward, and it did appear as though this vehicle had just stopped for no reason. Just stopped. Why would you just stop? That question had to be answered, and it turned out it had to be answered at court. So the case was raised, and I think it was November 2018 was when the case was actually heard. And it's one of the few decisions where the particular sheriff who was hearing the case found in favor of the pursuer, found in favor of Leslie. And he effectively, in his judgment, he ruled that there is no rule in a collision where there is one vehicle going into the back of another, which automatically gives rise to an inference that it's a vehicle that's gone into the back of the other that's at fault. And he was able to recover 100%. So you have an almost full flip there. He was offered an 80-20 split by the panel solicitor, and we were able to get to a situation where he was awarded 100% of his damages. Wasn't at fault in any way. And the main takeaway lessons from this particular case are the appointed panel solicitor failed to investigate the claim and appreciate Leslie's position as a motorcyclist. The panel solicitor was far too keen to accept the first offer and didn't look at previous reported case law. Again, comes back to the expenditure problem that they have. The panel solicitor never met the individual witnesses who were involved, and they would never have been able to successfully argue the case. And every case is always fact sensitive. You can't have a apply all rule to an individual case. It really does have to come down to the circumstances involved. You can't just look at a case and go, well, he's gone into the back of her, therefore he's at fault. That's not how it works. And that's not how a competent solicitor would look at things. So this is one of the situations where it's a really good feel-good story, actually, and where we're able to completely turn around what could have been a miscarriage of justice. Now, the next case I'm going to talk about is similar in nature in that there was an offer in relation to liability which didn't really reflect what the incident circumstances showed. The gentleman involved in this case was a fellow by the name of James, and he was motorcycling along this road, the A76. I've talked about this particular road in a previous webinar in relation to another client. So it's obviously a fairly common black spot. He'd effectively begun what, in his view, was a safe overtake just prior to the junction. And as he was almost passing the junction, a vehicle turned right across his path, caused a collision. James was referred to a panel solicitor by his own insurance company, and the panel solicitor never even met James. They didn't go see him. They didn't take a decent statement. They didn't do anything. And they suggested he accepted a 50-50 split in liability to settle his case. And James came to us and he said, I'm not happy about this. So we requested the file. And when we got the file, we were a little bit concerned because no police report had ever been obtained. There was no attempt to meet with the reporting officer who was there at the incident scene. It transpired that both James and the driver who caused the incident were insured by the same insurer. Conflict of interest, perhaps? So James was naturally furious. He was told that, he should accept a 50-50 split. So he approached us, and as a starting point, the first thing we did was we went and met with James, because that's what you should do. We met him at his home before COVID times, and after taking a detailed statement from James, we did what should have been done at the outset. We investigated fully, we took statements from witnesses who were there, chapter and verse, everything. And it became clear that the offer to split the case 50-50 was always unreasonable. When we went to the actual site, the locus of the incident, investigations, everything we had done, all the evidence pointed to what James has said all along, that he was there to be seen and he had made a safe overtake. So eventually we got to the point where we had to raise proceedings in court. And the difference we made was quite simple. It was just investigating the claim fully. And what happened eventually was a number of offers were made, and then finally a reasonable offer was made. And James was able to walk away with a settlement that actually adequately reflected A, the injuries he had sustained, and B, his contribution to the accident. There was never a formal agreement on liability, but the long and short of it was 100% settlement in his favour. So that's another example of a panel solicitor horror story on relation to liability. But there are some times where liability might not be an issue, and you could still be at the mercy of a panel solicitor when it comes to valuing your claim. Now, those of you who are particularly keen might have stuck around and seen one of my earlier webinars where I went through how to value a claim. And there have been colleagues of mine who have also done a few talks on how solicitors value claims. I'm not going to dip into that too much, but what you can see up there on the screen is what's known as a statement of valuation of claim. So whenever you have a case and you're looking to settle it, there are a number of heads of claim that you as the injured party might be entitled to. And there are values attributed to each of those heads of claim in order to compensate you, to try and put you back into the position you were before the accident. It's not winning a prize, it's just trying to recognize that a wrong has been done to you and putting that wrong right through compensation. And this case came to us in October 2018 when we received a call from a motorcyclist in crisis. What happened is, following a collision in May of 2018, he was just meters from his home at the time. He'd been injured and he was absent from work, and he was really struggling with his appointed panel solicitor. Now, the difficulty was that nothing he was being given in terms of advice was tailored to his needs. And as settlement loomed, so the case had almost gone fully to conclusion, there was a letter from his panel solicitor to say that an award around about the £3,500 to £4,500 mark would be what he should be expecting. Now, in this particular case, the gentleman was called John, and he had fractured his right ankle and bones in his right foot. John was also a manual worker. He was on his feet all day. His occupation required him to be on his feet. So even though he was able to return to work within a reasonable time frame, he was still unable to work overtime. And he was unable to work overtime for over 6 months in the end. And there was a huge reduction in his earning capacity. So we set out to work obtaining independent assessment from an orthopedic surgeon, which should have been done in the first instance. not a panel solicitor doctor's chambers report, which was previously on file. And that surgeon supported John's claim that he couldn't do overtime for a period of 6 months post-work. And that whole aspect of his claim had been completely missed by the panel solicitor, just not taken into account at all. And the starting point with these things is always with the client. What's unique about the client? What is the client's story? And we quantified John's claim after thorough investigation, and the table opposite you can see in red represents our valuation of certain heads of claim in relation to the panel solicitor's valuation. So you can see there at the very top, injuries, the avulsion fracture I mentioned to the right ankle and the fractures to the second and third toe. The panel solicitor said that's worth £3,500 to £4,500 mark. Rubbish. We put a valuation of 15,000 on that particular head of claim, which was reasonable when you look at the case law and you look at my favorite bedtime reading, the Judicial Studies Board guidelines. This is how us solicitors value claims. There was a wage loss element, refundable sick pay. You can see up there huge amounts of things which weren't even claimed by the panel solicitor, which could have been included as part of John's claim. So there were huge glaring omissions on the part of the panel solicitor, and they failed to adequately calculate his loss. And you can see the difference in final settlement at the end. We were able to achieve a settlement figure of £18,125, whereas previously the panel solicitor's valuation fallen well below that. So it just shows you again, the important thing is everybody is an individual. Every case is fact sensitive. I'm sorry to go on about panel solicitors and accident management companies, but the message here is clear. You are an individual and you have the right to choose your own solicitor. And if you choose to appoint Motorcycle Law Scotland, what we will do is we will investigate the claim and treat you as an individual, because that's what you are. We're always here on hand to offer advice. We offer a free advice service. It's free, so please don't feel as though you can't give us a ring. I would encourage you, even if you're involved in an accident and you call up your insurer and you're sent some documentation, if you're not sure about it, give us a call. Even if you're happy with going with a panel solicitor, even if you're happy with your insurer dealing with it, just give us a call if you're unsure at all about any documentation, because it can be a little bit mind-boggling. And we are here on hand to help the motorcycle community in whatever way we can. So I would encourage you to use that service. And I suppose the takeaway point here is that it's a little bit cheesy, but our tagline is we don't just make the difference, we are the difference. And I think, even though I say it's cheesy, it's really that's our raison d'etre is that we are the difference. The case studies do show that we really do make a difference when it comes to these incidents. And I'm very pleased that we were able to avoid what could have been potentially miscarriages of justice happening to these clients. But the problem is it's still happening across the board. And the reason for that is volume. An insurer is always going to be the first point of contact for any of us if we're involved in an accident. And we want to do our utmost to try and ensure that as little of these cases are going to the panel solicitors as possible, and that people are getting fair legal representation. It doesn't cost them any more than it would ordinarily, but the service you're provided with is ultimately one that's above and beyond what you would expect from a stack 'em high, sell 'em cheap model. And that's my takeaway message, I suppose. If there are any questions, do let us know. I think I saw a few coming in as we went along, but I'll be on hand should you wish to contact me directly. I'll hand it back over to Rod, who'll be able to address any questions to me. But thank you very much, everybody.
Brilliant, Thomas. Thank you very much for that enlightening presentation. I hope everybody is better informed now. Certainly from the comments I'm seeing coming through, people are now clear about exactly what might happen and where they should go. We've had about 5 questions that have come in, actually. I don't know if you can see them there yourself. One in relation to an individual who asked, is the accident management company who do the initial, is it them who do the initial recovery of your damaged motorcycle?
So it depends on the circumstances. A lot of the time, the answer to that is no. What might happen is a local company, a local recoverer might initially recover your motorcycle to a local garage. And then once you've contacted your insurer, then they'll arrange for uplift of your motorcycle from the local garage. And what happens with these storage credit agreements sometimes is what will happen is Fourth Dimension or another type of company will inherit the charges that the local garage has incurred for storing your bike, and they'll include that as part of their charges at the end of the claim. So normally no, but it depends how quickly you get on the phone to your insurer. A lot of these management companies are based south of the border, so they have to send vans up in the first instance. So the short answer is no. The long answer is in due course, they do recover it, but normally after the fact.
Is it the police that arrange for that recovery by a local company?
Sometimes if the police are on the scene, then yes, they will. Police often use a company called 911 Recovery. Sometimes it can just be if the police have arrived and they've informed a local authority or they've informed anybody. It depends who's on the books or if there's a local recoverer who gets the call. It does depend. Sometimes it might be you yourself calling a local recoverer or somebody you can find in the area, depending. It does depend on the circumstances, but ordinarily it won't be them who do the initial recovery, but they will recover it eventually.
Okay, there's an anonymous person here, I don't know if you can read this one, where he was involved in a non-fault RTC, refused to use the claim handler for repair, who he believes it was Plantech, which is the other accident management company you referred to, as he wished and requested that the dealer, his local dealer, did the repairs. However, he's injured his hand and he's damaged his helmet, and he's basically been left to his own device by the solicitors and third-party insurance, which kind of goes with what you were saying earlier in relation to that. He's asking, is he at a disadvantage, or will it just take longer for his motorcycle to be fixed? His dealer's having trouble getting approval for the repair from the third-party insurer. Again, not surprising. And he was also saying, I wasn't happy with the service I received from the appointed solicitor. Would I be penalized if I moved to another company? Well, again, you've covered that, but I don't know if you want to summarize some of those.
Yeah, I suppose it can be difficult if you're using your own repair because, yes, you do need approval. One option is always, if you have funds, you can choose your own. Say if your motorcycle isn't damaged that badly and you've got enough cash that you can actually have it repaired. If you just keep a receipt, you can claim it from a third-party insurer at a later date. If it obviously needs, more extensive repairs, then yes, you are obviously having to wait until you get approval from the at-fault insurer. But what an accident management company is able to offer as a service, I suppose, is they're able to repair it ahead of time and then delay recovering that cost. So the inconvenience to you is less. You get your motorcycle back, or you get it written off and you get the check in the mail, whatever. And then they seek to recover the costs at a later stage. But it really does depend on the individual circumstances of the case. I would always caution against using an accident management company if you can avoid it. But at the end of the day, they do offer a service, which is sometimes expediency, and they certainly do provide that. So there are advantages to using them at times.
Okay, Paul asked a question. He's insured on another car within his household. So if he was involved in an incident, is he going to be penalized? Should he avoid getting a hire bike? Is he going to say to him, well, actually, you could have used one of the other cars in your own household?
Yes, that will be an argument that would be advanced by a third-party insurer or a solicitor representing them. You have to mitigate your loss insofar as you possibly can. That is a number one duty on you as the injured person. You have to do everything you can to make sure that any losses stemming from the initial incident are lessened if they can be. And if you have access to another vehicle, then they'll turn around and say it's not reasonable for you to have a hire motorcycle. That's the long and short of it. And it can sometimes be quite difficult to overcome those arguments, particularly if the hire charges are much more expensive than, say, if you hired a bike privately from a local garage, for example.
Okay. Rab's asked the question. I think we've answered this, but I'll just confirm it. If my policy includes legal expense insurance, am I obliged to use it?
No. The answer to that is short and sweet. No, you don't have to use it at all.
The insurer might be quite forceful, actually, sometimes. But they still need to know their rights, don't they?
Yes, you do. I mean, you're entitled to appoint your own solicitor to deal with any uninsured loss. Remember, your insurance is for your insured property. Legal expense protection, it's a scam, really. You don't need it. A lot of solicitors will actually, every solicitor in the personal injury sphere operates on what is colloquially known as a no-win, no-fee agreement. So there are never any upfront costs for you anyway. So there's no such thing as legal expense. You don't have legal expense in motor claims coming from personal injury because all the cases are funded by the solicitors you instruct. It's a scam, it's a sham. I would avoid it at all costs.
Okay. Someone's asking, after an accident, what sequence of things should I do for the best results? Well, I think the answer is give us a call.
The first thing is, if you can, take photos, obviously, at the incident scene. Report it to the relevant authorities. So if the police haven't attended, always call the police and just report it if you're able to actually right away. It is important, even though I'm discouraging the use of legal expense insurance, you do have a duty to notify your insurer that you've been involved in an incident. That's an important point. But if you have been injured, then you can appoint your own independent solicitor. That's an option open to you. Sometimes it is within the particular policy you might have. It will say, we will choose a panel solicitor for you, but you are entitled to seek independent legal representation. So always take advantage of your entitlement to do that.
Okay, Billy's asking, are all insurance companies as bad as each other, or is there a difference with any of them? Well, that's
no.
There are some that are better than others in terms of how you can interact with them, and ultimately they all look after their shareholders because that's what they're there. But
yes, it's probably a bit unfair to say they're all as bad as each other. The difficulty is we all need insurance to ride our bikes on the road, and insurers know that, and therefore the prices of insurance always seems to go up year on year, even though you're less of a risk. So my own personal view is, yes, all insurers are as bad as each other, but if you can get one with decent customer service, you've won half the battle. The best thing is if you never have to use your insurance for anything and they're just there to provide customer service and allow you to ride your bike on the road. That's the best scenario. But in general, insurers are difficult. They only care about their shareholders and their bottom line. They don't care about you.
Okay, one final question, I think, Thomas. When dealing with a claim where the client is not at fault, or obviously they're not at fault, do we take into account the value of the motorcycle? I guess that depends which route they've gone down in terms of getting it repaired.
Yes, even though you can instruct a personal injury solicitor, an independent one, to deal with the uninsured loss, there are occasions where you can instruct them to deal with the insured loss. And those occasions are when you say to your own insurer, I do not want to invoke my comprehensive cover. I don't want to use my own insurer to make a claim. I'd like to claim from the third party. In those situations, if you've instructed Motorcycle Law Scotland, what we would do is we would appoint an independent engineer to come to your house or to come to where the bike is, to provide a report on what repairs are needed or whether or not the bike is an economic write-off. And then we would intimate that report to the at-fault insurer and try and seek an early interim payment for you in respect of your claim so that that aspect of your claim can be settled at an earlier stage. I can never promise that claims move quickly, but that is an option open to you if you wish, particularly if it's a non-fault claim, as the question suggests. You can have everything run through your personal injury claim, which you conduct separately. There's no problem with that at all, and there are certainly ways and means to do that.
Great. And I've got one final one, because I know this has been asked before, but hasn't come up today. So I've got a claim outstanding. It wasn't my fault, and it comes to renewal time. And I'm told, I'm sorry, you've got an outstanding claim on your policy. And I'm going, but wait a minute, why has my premium gone up when I wasn't responsible? What take, do I have any kind of way I can get back at the insurance company to consider that, or what happens there?
It depends on how the insurer works. Some insurers have, so if you have a claim ongoing, particularly one that's non-fault, they might have it known as what's under review. So they will tell you that the claim is under review. So we can't quite put it down as a non-fault yet, but upon conclusion, you can come back to us and say, yes, it's concluded now. In those situations, you are normally entitled to a refund on any increased premiums, and an insurer would recognize that. So if your premiums have gone up £100 because you have a pending claim and then it's concluded successfully, you'll get that £100 back because it will be noted as a non-fault claim.
Reality is always phone your insurer anyway at the time of renewal, because they are desperate to hang on to your business. And you'll find that they'll probably match what you might get on Compare That Bike or CompareTheInsurance.com. So yeah, work hard, and they will look after you, I think, to try and retain your business at any cost.
Yes, you're the customer at the end of the day, and there's lots of options out there. If we know one thing, there's an awful lot of insurance options. So always be the wheel which squeaks the most, because you'll receive oil.
And on that note, Thomas, thank you very much indeed. Well, all that remains for me, first of all, is to thank you for the presentation tonight, an illuminating presentation once again. So thank you for your time, particularly on a Monday night. You'll be able to do something more useful. Sorry, it's not Monday, it's a Thursday. You'll be able to do something more useful on a Thursday evening. So thanks once again. And to everybody who has joined us, not just tonight, but over the last 8 weeks, thank you very much for joining us. I hope it's been useful. I hope it's been beneficial. Hope you've taken something away, and we hope you'll never have to contact us. But if you do, we'll be here for you. Thanks very much again, and good night.
Thank you, everybody.